Welcome to Advisory Opinions. I'm Sarah Isgur. That's David French. And David, I don't know how long this podcast is going to go. We're just going to have to go until we're done. We're going to start Supreme Court update. We'll do as many Donald Trump EOs and bigger conversations as we can get to. And then we've got sort of three of these big picture questions: the American dream, how to get your name on a SCOTUS case, and our law reviews the problem. We're going to tackle one of those today, the American Dream one, and then we're just going to have to tackle the other ones next week as they come. Because, David, I mean, I do think it was the point, the 200 or so EOs, executive orders from the president, but it's too much. All right.
It's way too much. It's way too much. And some of them, we don't even know yet if they're actually significant. You know, you have to wade through all of this stuff, and a lot of the early reporting is just top line off the EOs that were sort of broadcast and forecast. And he wrote them. And so you were primed to look for, say, the TikTok EO or the, invasion EO or the birthright citizenship. But there's a lot there.
Okay. First up, the Supreme Court granted cert in a case that we did watch a little bit, David. This is Mahmoud versus Taylor. This is the QP. Whether public schools burden parents' religious exercise when they compel elementary school children to participate in instruction on gender and sexuality against their parents' religious convictions and without notice or opportunity to opt out. Okay, right off the bat, and I see the word whether public schools can burden parents' religious exercise, and I'm like, well, they're going to lose because the Supreme Court hasn't seen a free exercise case that they haven't loved in decades at this point, really.
Right.
But you get to the details on this one, and it kind of cuts both ways. It's not all then, oh, never mind, they lose either. Now I'm just, David Latt wrote this up too, and he was kind of like, what? So this is about very young elementary school, kindergarten age children. The books that are assigned in class, they initially sent parents the list of books, and the parents sort of had to sign a permission slip. They basically, it was an opt-out. And then the school, I think, realized that's insane in terms of administrative burden. And so they stopped the opt-out policy. And so this is the lawsuit that results. And yes, some of the books I would not want my child reading, not because necessarily they have to do with LGBTQ plus stuff, but because my kid doesn't need to know really graphic sex stuff in kindergarten, like the ABCs where they're learning it from a pride parade, and there's leather is for L is for leather, and what was this one that was C is for clamps or something, and I was like,
oh my gosh,
yeah,
and
really?
and again, this is kindergarten.
I think this was kindergarten.
Oh my gosh.
But the other problem you have in this case, David, is that it's not fully developed. This is coming up on that preliminary injunction type posture. So we don't have a full record. So not only do I not know all the details, neither do the justices and neither will the advocates. So this one's going to kind of be messy. But I bring it up not only because I want us to talk a little bit about the topic, but also because it is probably the last case getting argued this term. So we're now at that point where when they grant cert to any future cases, they're almost certainly going next term. This is usually the dividing line for the cert grant. So congratulations, OT24. You're fully booked now.
Well, Sarah, you know what I'm going to do now. You know that I'm going to bring up the case. I have to bring it up once a year in Advisory Opinion, which is the very first constitutional case I ever worked on in my entire life. I was a 2L? Yeah, 2L. First semester 2L year. I was asked to do some legal research on a side issue on a case, because they don't ask the 2Ls to do the core work. So I was working on a side issue around substantive process in a case called Brown versus Hot, Sexy, and Safer Productions. And that's the name of the case. And Hot, Sexy, and Safer Productions was a traveling sex ed group in Massachusetts. And, one of my themes, folks who've listened to the Advisory Opinions know that one of my themes that I consistently talk about is that there are there's nothing new under the sun. A lot of the stuff that you think this never used to happen before, because you saw this on Twitter. Oh, it has been happening, and it's been happening for a long time, and there's even been cases about it. You just didn't know about it because in the pre-social media era, you weren't instantly aware of every outrage the way you are now. So in my case, here were the facts, Sarah. And I just, if you have small children, I'm not kidding. If you have small children in the audience, you might want to turn this down or skip forward like 30, 45 seconds. But here are the allegations in the complaint. The complaint alleges that this group, one, told students that they were going to have a group sexual experience with audience participation. Two, used profane, lewd, and lascivious language to describe body parts and excretory functions, advocated and approved oral sex, masturbation, homosexual sexual activity, condom use during promiscuous premarital sex. It also simulated, letters matter, simulated masturbation, characterized the loose pants worn by one minor as, quote, erection wear, referred to being in deep beep after anal sex, had a male minor lick an oversized condom with the presenter, after which she had a female minor pull it over the male minor's entire head and blow it up, encouraged a male minor to display his orgasm face with her for the camera, informed a male minor that he was not having enough orgasms, closely inspected a minor and told him he had nice butt, and made 18 references to orgasm, 6 references to male genitals, and 8 references to female genitals. Okay.
Okey-doke. Feel like I got this one.
Yeah. And they were forced to attend. They could not leave.
What?
Yeah. When they tried to leave, they were told they had to stay. These were some Christian students. And so, yeah. And Adam, feel free to cut some of that. Like,
no, I think it's relevant.
Yeah. I know. I mean, wait a minute. Did I just shock Sarah?
A little bit, actually. I can't. This is the first time in our 5 years that I ever feel like, oh, David.
I know. Like, I'm looking at your face and you kind of have this like look of, what are you doing here? And I'm feeling terrible. Like, I feel gross. What have I done? But the students lost. The students lost this case. And the reason, when you go back to this point in time, the free exercise angle of it was toast, done, over, because this was right after Smith. Free exercise was at a real low ebb. So you had to go for another theory. One of them they tried with substantive due process, which was just an absolute loser. But the court's reasoning was, wait a minute. Look, when you go to school, you're in an in loco parentis situation. You have handed your children over to the school. The school has taken the place of the parents. Now, you as a parent, you have input through the democratic process into the curriculum of the school. You have input through the democratic process by speaking up at school board events and urging them not to hire this group or whatever. But you don't have veto power over curriculum. And so even this, which, by the way, Sarah, is actually looks, I think now you might have a Title IX sexual harassment claim.
I mean, some of that was just obviously not acceptable.
Oh, my gosh.
Telling a minor student, like, commenting on his physical appearance in sexual ways, like,
yeah,
no.
Yeah, I know. So I want, but they lost that case. And we have other cases. There's one we talked about from the Ninth Circuit years and years ago, which colleagues of mine filed suit, where part of the facts is they were exposed to different world religions. And in one of the exposures, they actually participated in something approximating a Wiccan ritual. But
here's the problem, David, as we're going to see in this case. I mean, if before oral argument, when we just have the briefs, and this is coming up through the Fourth Circuit, the school won at the Fourth Circuit, the students lost. So exactly the same as your case. I kind of think the Supreme Court's going to uphold the Fourth Circuit because the alternative doesn't really work. Like, every parent can now raise a religious objection to any part of a state curriculum that they don't like. I mean, this is why we need school choice, but it goes back to this who gets to decide.
Yeah.
And it's the same as the libraries. It's all of this. And it's like, well, we have a politically accountable system. And you just need to get involved in that if you want to change the curriculum. But otherwise, we can't have every single person get to have their own opinion on what's taught and how it's taught and which books it's taught with, as absurd as this is. So, by the way, so I have now, this was for pre-kindergarten and Head Start classrooms. So 3 and 4-year-olds, David, pre-kindergarten.
Oh boy. Now are you about to shock me now?
No.
Okay.
No,
you're not as bad as I am. I mean,
Right.
let's just be
I'm
real.
no David French. So this is that alphabet book again. I was right. L is for leather and lip ring. D is for like drag king and drag queen. U is for underwear. Again, I'm not objecting to that for religious reasons. And I'm not objecting to it because it promotes an LGBTQ lifestyle. I'm objecting to it because it's way overly sexual, and we're just not doing that in my household.
Right.
4.
Under what, look, I mean, let's put off, let's just take sort of religion out of it for a minute. From what standpoint of childhood development is this acceptable? Or do they have the reasoning skills to comprehend what is being discussed here? I mean,
yeah, it's also, by the way, super stereotyping, caricaturing LGBTQ folks. Like, everyone has a lip ring and wears leather chaps. Like, give me a break. Yeah. I would find that really annoying.
Right.
But in the who gets to decide, I think the proper way to do this is to go and convince the school board / run for school board / vote out those people from the school board, or go to the state legislature and win at that point. There's a lot of actually different levels and accountability when it comes to school curriculum, but I don't think they're going to win this case. But the Supreme Court did take it, and just from a percentage chance, of course, they've got about a 60% chance of winning this case.
Yeah, it's a fascinating issue because, the idea, there's no neat, clean answer here because, as you say, Sarah, on the one hand, the facts themselves, what is being taught to these kids, the textbooks that are being provided to these kids are absurd. And look, we've had a lot of anger around the country around textbooks and things like that. But the fact that a lot of people who've gotten angry about textbooks have gone way too far, like way too far, such as in my area of the country where they tried to ban Ruby Bridges Goes to School, doesn't mean that there weren't very many instances where people were angry and had a point, that, when they looked at what was happening with their kids, they saw stuff that they really, really didn't like and activated to do something about it, which is the democratic process at work. But at the same time, so that part of it, you can sort of see that unfold in real time. But at the same time, is it the case that if you lose, if you run for school board and lose, or you approach the school board and they say, nope, L is for leather for kindergartners, that's the rule, are you just utterly without recourse except for if you have money or a voucher to go somewhere else? Is there nothing, does the in loco parentis and the curricular control of a school, is it so potent that there is literally, once you've lost in the democratic process, just nothing you can do? And that was basically, if you're talking about hot, sexy, and safer, that case, unless you could point to a specific incident of sexual harassment against the student plaintiffs, for example. I mean, you were in the school's hands. And is that the rule? This is one of those cases, Sarah, that I'm going to be very interested to read the briefs and hear the oral argument, because both sides to me have a very tough kind of real world practical problem, which
I actually think your Ruby Bridges point is really worth underlining, because whatever the rule here is, the rule is also going to be for not having Ruby Bridges in school.
Right.
What's good for the goose is going to be good for the gander. So just because this involves leather and lip rings, if I'm going to say it's a who gets to decide type of case, and the state gets to decide the curriculum for a public school, then the state of Tennessee also gets to decide that they don't teach Ruby Bridges and that book is banned. That's the exact same issue being teed up. Take out the religious burden question, I suppose. But, as the full QP was presented, I'll read the full thing here. whether the Fourth Circuit correctly concluded, consistent with every other court of appeals to have considered the question, that parents' free exercise of religion is not burdened by their children's exposure as part of a public school curriculum to material that the parents oppose on religious grounds, absent any evidence that the parents or their children were coerced to change their beliefs or act contrary to their religious faith. And I want to be clear, that's the QP that the school asked to be accepted by the court. It's not the one that the court actually ended up accepting. But that's sort of their version of this case. And David, I'm really uncomfortable with that QP.
Yeah.
You have to have proof that the school was trying to coerce the children to change their religious faith? Like, surely not. No,
surely not. Surely not. No, I am super interested in this case. Can't wait to devour the briefs. But, what's interesting, just to kind of circle back to my point about the past versus the present. So I was not that far out of high school when I worked on the Hot Sexy Safer case. So weird to say that case. But anyway, I was not that far removed from high school. And reading those facts, what's so weird, they were more shocking to me now than they were then. And I'll tell you why. Public high school in the 70s, 80s was crass. I mean, from the teachers all the way down to the students, the data is overwhelming. Like the big three vices of the, 70s, 80s, sex, drugs, rock and roll, like the thing that's what parents really worried about. Kids were drinking more. Kids were more sexually active. There was just a lot more of sort of these classic vices going on at that time. That was the culture. And this shift that I've seen with, say, my kids is when they went to high school was actually a lot more moral in the classic vice sense. Like there was less, and this tracks the social science, around the country, less drinking, less sexual activity, less sort of less criminality. There was more criminality when I was in high school, more alcohol, more sex. And now there's less of all of that, but it's much more ideologically and religiously wide open. So a lot of, we were all, I was the nerd playing Dungeons and Dragons while all my classmates were out there doing all that stuff, but everyone was doing crazier stuff, but more uniform culturally / politically and religiously. And now people are more restrained in their conduct, but more diverse culturally / politically. And so it's interesting how the change to more ideological / religious diversity has in some ways created more alarm than the higher degree of vices, that some of which could be catastrophic at an early age. But when there was more ideological and religious uniformity, that just is interesting to me, Sarah.
I also find myself really interested in the reverse of the vices, and that actually I now think it's a sign of real mental health problems for this generation. The fact that teenage pregnancies may be a bad example in a lot of respects, because there's a lot of reasons that teenage pregnancy could drop beyond just not having sex. But we do know that, in fact, they're having less sex as teenagers. They're not as likely to be drinking. All the things that sort of test boundaries were considered rebellious behavior have all dropped in this generation, and they're not doing well. So I find myself longing for the days of, teenage keggers and people dying to get their driver's license and sex among minors. This whole podcast is
oh boy,
so much trouble.
Gosh.
But you think, let's take the driver's license thing, because it's maybe the best example. 16-year-olds, many of them are just sort of like, maybe I don't, it's not like a huge moment in life the way that for everyone of any generation before, like that was literally your ticket to freedom. Finally, unless you lived in Manhattan. And so like the whole point that the whole change that you're noting, David, I think has actually also had really negative consequences on the vice side.
Well, and let's put what you're raising. So I was in San Diego over the weekend and heard a fabulous presentation by Jean Twenge, who has been doing research on generations for a long time. She's, did early research. She did research on millennials. She did some of the most important early research on Gen Z. She's collaborated with Jonathan Haidt. A lot of listeners follow her and know her. She does a fabulous job speaking in person. And there's an interesting underlying reality here, Sarah. It is not necessarily that students have more moral objections to alcohol or they have more moral objections to premarital sex. It is that they're not spending time together. And when I was growing up, I mean, obviously sex requires time together, but all of the other stuff, you were eager to get your driver's license to go spend time with your friends. The keggers and the ragers, or whatever you want to call them, were all group social activities. And so the danger element was much more physical, as by and large. Although I will put a pin on, there was, the level of also sexual abuse and predation that could occur in those circumstances could have extreme psychological consequences, of course. But by and large, a lot of the discussions of risk at that time were more physical than psychological. You could drink and drive and crash your car, teenage pregnancy, like you mentioned, or you could get hurt in some way, even if it's, not a fatal accident. You could get drunk and do something out of control and have a criminal record and destroy your future, those kinds of things. Whereas now it's much more, what do I do with my kid who is so anxious and depressed? And so it's gone from sex, drugs, and rock and roll to concerns that parents have. The big three are depression, anxiety, and suicidal ideation. And one of the things that you see is that all of that suicidal ideation and depression and anxiety is connected. It correlates very strongly with the rise of the smartphone. It also correlates very strongly with the decline of in-person activity, being with other human beings. And one last thing on this, because we've totally hijacked this podcast.
A little bit.
But this is important stuff. One other thing that was really important is Jean put up a graph of what are the things that make teenagers happier? What are the things that make teenagers more unhappy? So almost everything associated with teenagers becoming more unhappy was screen affiliated or screen adjacent, the social media use, things like this. But the top three of the things that actually made teens happier was, number one, sleep, more sleep. Now, this was fascinating. And also she was talking about how the screen use actually really destroys sleep. Teenagers call it vamping, being a vampire. You're up late at night, doom scrolling. The other thing was regular attendance of religious services. Another thing was regular in-person interaction with friends. So two of those top three things have in common community. One of them is just physical. It's just sleep. The older I get, the more I think sleep is like a superpower. But the two of those top three were communal. And then all of the stuff clustered at the bottom was centered around screens. And so, yeah, I am so sold, Sarah, on no phones in schools. I'm sold on that. Sold.
All right, we've put it off long enough. Now we need to move to Trump's executive orders. Okay, so almost all of these are going to result in lawsuits. So before we dive into any given one, David, let's talk big picture here. I mean, is there any better example of why, if you love what President Trump has been doing, you should be really concerned, because these aren't going to last. They can only last for the length of his presidency, really. And if you're really upset by what President Trump is doing, think about how much power the left in particular has wanted to locate in the office of the presidency. Is there any better example than the first 24 hours of Donald Trump's presidency that something is horribly broken if a president can change so many of our laws with literally the stroke of a pen on his first day in office?
Oh, Sarah, you're singing my song. I have the great fun of teaching a class on the legal philosophies of the American foundings at Lipscomb. And we've been talking a lot about how the founders, the 1787 Constitution, really was dedicated, and Remember, the 1787 Constitution did not include the Bill of Rights. That's later. But it's really dedicated to preserving liberty and preserving the American experiment by systematically dismantling anything that looked like royal authority, just systematically. You know, the old kings, they were the warrior, they were the politician, they were the judge. And in England, they were the priest, they ran the church. And so you had all of those functions being systematically pulled away, or at least diffused through other branches of government. And that giant sucking sound you hear is the sound of presidencies over the years pulling back all of this, a lot of that authority to themselves that the founders had intentionally divested from the presidency. And we're seeing it now. Now, Trump is taking more power than precedent allows, but there were a lot of steps to get to where we are today, where he's writing all these executive orders. So the foundation for this week had been laid a long time ago. So this is not Trump jumping in and doing something that is completely outside of American norms. We've been building to a moment like this for a while.